Good evening, everyone. Today, we'll be discussing about the recent judgment of the Honorable Supreme Court in the case of Rajpal Singh. Okay. The matter was leading to compulsory acquisition, and the Honorable Supreme Court pronounced its judgment on the uh, matter that when the transfer is said to have happened in the case of a compulsory acquisition. Okay, so we'll just run through that judgment today. So I'd like to thank Akash for putting up this presentation. And the legends are fairly simple. There's nothing much complicated on this, so it's straightforward. And we'll start off with the brief facts about the case. Okay, the assessee, Mr. Rajpal Singh, the Karta of the Amrik Singh HUF, the assessee, had bought a land from a person who migrated to Pakistan. Okay, the original owner gave some part of the land to S.A. Jain College on lease for 20 years, which was expiring on 31/8/1967. Later, the college moved to the government of Haryana for compulsory acquisition of the whole land. Okay, and a notification of Section 4 of the Land Acquisition Act 1894 was issued by the government of Haryana on 15/5/1968, seeking to acquire the subject land for public purpose. The notification was followed by the declaration dated 13/8/1969 under Section 6 of the Act of 1894. Okay. Ultimately, after submission of the claim for compensation, the land acquisition collector, Ambala, proceeded to make the award on 29/9/1970. These dates are important because the lease expired on 31/8/1967. Okay, and the college moved to the Haryana government to compulsory acquire the land on 15/5/1968. Okay, and the award was actually made on 29th September 1970. The case of the assessee was selected for scrutiny, and ITO passed an order dated 12/2/1982, enhancing the income from HP and adding the interest income received as per the award date. Okay, the issue related to income from house property is not much relevant for us. Okay, on an appeal with CITIA appeals, question arose as to why the capital gains shall not be taxable in the year of receipt of award. The whole issue in this case is when is the capital gains in which year the capital gains has to be charged, or in other words, when is the transfer said to have happened. Okay, whether in the year of award or whether in the year of the possession being transferred, or whether in the year of issue of notification. The assessee contended that the transfer was related to Section 17, that is urgency acquisition of the Act of 1894, and therefore the transfer shall be when the first notification was issued, that is in Asthman year 1968-69, when the first notification for acquisition of the land was issued. So this point is very important. This is important to note that the acquisition being under Section 17 is the assessee's contention. There was no clarity in the notification. It was not made clear in the notification that whether it is the acquisition under Section 17. The notification was silent on that part. Since it is being acquired for public purpose, he has assumed that it is under Section 17, because this plays a very crucial role in understanding the case law and the final judgment. So it is assessee's assumption that the acquisition has been made under Section 17. It is an urgency acquisition, since it was for a public purpose. But the notification does not specify explicitly that it is acquisition under Section 17. However, the CITIA appeals held that until the actual amount of compensation has been fixed, no income could be said to have occurred, and therefore it should be taxable only when the award was announced. The CITIA appeals ruled it in favor of the revenue and said that the transfer is said to have happened only when the award has been made. On an appeal, the ITAD held that since no actual date of acquisition has been mentioned either in the award order or by the ITO, same has to be ascertained at the first stage. The ITAT also referred to the similar case of the SSC for the assessment year 1975-76, whereby that was a clear case of urgency acquisition and position was taken on date of notification under section 9(1). So this is important. The SSC also had a similar case for one more assessment year, that is assessment year 1975-76, which was a clear case of acquisition under section 17 of the Land Acquisition Act. That is nothing but the acquisition for under urgency purpose. Okay, but in this present case, which is under consideration, it was not explicitly mentioned in the notification that it is a urgency acquisition. The ITAT had mentioned that it is certain that the possession of the land was taken before the award was made under section 11 of 1894. Here, what has happened is, upon the expiration of the lease period, okay, the college or continue to enjoy the possession of the land. Okay, so that is what happens by virtue of which, even before the award was made or before notification was issued, the land was already under possession of the college. So now since as already mentioned the facts of the case, okay, the case was again referred back to the ITO by the ITAT. Okay, the assessee contended that the transfer was covered under the urgency matter of section 17 of the Act of 1894 and therefore taxable only in the year of notification, that is assessment year 69-70. Okay, the ITO, after making enquiries from the revenue, concluded that the date of transfer for the land in consonance with the date when when the award was announced. There is two different contentions here. One, the ITO says that the date of transfer is nothing but the date of award. Okay, whereas SSC contends that since it's under his assumption that it is under his contention that it is case of urgency acquisition, the date of transfer shall be the date of notification. For the case relevant to assessment year 1975-76, the ITO clarified that specific date of taking over of possession was mentioned in the notification as per section 9 of the Act of 1894. See, as I said earlier, in the other case of the second case of the SSC relating to assessment year 1975-76, since it was a clear case of acquisition under urgency matters under section 17 of the Land Acquisition Act, the date on which the possession was being taken over was clearly mentioned in the notification itself. So hence, it was easier for the ITO to decide on the date of transfer. And then the same was not the case in the case of assessment in 1971-72, and therefore ITO held that in the instant case, the award was announced on 29/9/1970, and the said date shall be relevant to the to determine the transfer. As I said earlier, in the notification, since it was not a clear case of acquisition for urgency matters, the date of taking over of the possession has not been mentioned in the notification. Okay, so the ITO contested that in such cases, the date of award should be considered as the date of taking over possession by the government. However, in all, it is to be kept in mind that the land is actually under the possession of the college even after the completion of the lease period. Okay. The assessee's contention is on two grounds. One, the land is already under possession of the college, and second, since it is an acquisition for public purpose, it should be deemed as acquisition for urgency matters, and hence the date of notification shall be the date of transfer. But whereas the ITO's contention is that since the date of acquisition is not, date of taking over the possession is not clearly explicitly mentioned in the notification issued for land acquisition, the date of award should be considered as the date of transfer. The other important fact that is to be kept in mind is that in the order of for award dated 29/9/1970, the interest was awarded from the date of notification under section 4 of the Act of 1894. So to make the matters worse, okay, or to complicate the issue further, in the award issued by the collector on 29/9/1970, interest was paid on the compensation was paid to the assessee from the date of issue of notification. So this further, enhances the argument of the assessee, saying that the interest was also paid from the date of notification. Hence, the transfer should be considered from the date of notification instead of date of award. So in front of the proceedings with the CITIA appeals, the SC contended that the acquisition was a case of compulsory acquisition, as said earlier, of under urgency matter. Hence, the date of notification should be treated as the date of transfer. SC further contended that the in the order of award, interest was also awarded from the date of notification, and hence it is the date of notification should be treated as date of transfer. However, the CIT appeals rejected the contention of the assessee and upheld the order of the ITO on two important aspects. Okay, one is possession of land. The possession of land should have taken before the award date, and possession should have happened have been taken after 15 days of notice under section 19. So in case of the acquisition to be to be considered under section 17, two things are important. One is that the possession of the land should have been taken before the award date. In this case, this condition has been satisfied. However, the second condition has not been satisfied in the present case. Possession should have been taken after 15 days of the notice under section 9(1). So once the notice under section 9(1) is issued for the acquisition under section 17, the possession should have been taken 15 days from that date of notification. However, in this case, the possession of the land is there with the college much before the date of award itself. And second, the other argument of the CIT appeals was that about the payment of interest under from the date of notification of section 4. Interest awarded was not because of section 17, but based on section 28, and based on the ruling of the court, and based on an equitable interpretation of section 28 of the Act of 1894. So let us just run through the section 20. What does the section 28 of the 1894 Act say? If the sum which the collector did award as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took the possession of the land, the date of payment of such excess to the court. Since section 28 says that the collector shall be liable to pay an additional interest of 9% per annum from the date of taking over of the possession till the date of payment of the compensation. So in this case, since the possession is already there with the college and the compensation was paid at a much later date, based on this section 28 and based on already existing judicial precedents, the collector has paid 9% per annum, and the CET appeals condition is that this has nothing to do with the transfer of the property. However, this is purely based on the section 28's argument that the section 9% interest has to be paid on the compensation from the date of takeover of the possession till the date of payment of compensation. And in front of the ITAT, the proceedings with the ITAT, since the date of acquisition has not been mentioned in the notification, the ITAT has gone in favor of the assessee, saying that since the date of taking over of the possession has not been mentioned in the notification, based on the facts that the college has already continued to enjoy the possession even after the expiry of the lease, and based on the fact that interest has also been paid from the date of notification, it is the date of notification which has to be considered as the date of transfer. So ITAD ruled it in favor of the assessee. However, the revenue went on appeal with the in front of the High Court. So based on the High Court having analyzed the facts and circumstances of the case, the High Court ruled it in favor of the revenue. whether on the issue before the High Court was whether on the facts and circumstances of the case, the tribunal was right in law in holding that the capital gains are not accessible in the year under consideration, as the transaction did take place on the date of notification, that is 15/5/1968, and not on the date of award, that is 29/9/1970. As I said earlier, the tribunal ruled that the transfer has taken place on the date of notification. So the issue before the High Court was whether the transfer has taken place on the date of notification or on the date of award. So condition of the revenue was that as per the Income Tax Act, the capital gains are taxable in the year in which transfer takes place. And therefore, the date of award, 29/9/1970, ought to be considered for the purpose of calculating CG and not the date of notification. So, based on, as we explained earlier, since the date of acquisition has not been clearly mentioned in the notification, the department contested that the date of award shall be considered as the date of transfer. Whereas the assessee's consideration is already mentioned, since this is a case of urgency acquisition under section 17, the transfer shall be considered to have been taken place on the date of issue of notification and not on the date of award. So the High Court answered the reference in favor of the revenue while holding that the collector had not taken possession on the land under section 17, as a said possession was not invoked by the government. So the High Court very clearly made it very clear that the possession shall not be considered to be possession. So the acquisition shall not be considered to be a acquisition of section 17 of the 1894 Act, and it is not a acquisition for urgency purpose. It is only an ordinary acquisition of land. For the purpose of CG, the date of award was required to be taken as the date of taking over the possession, because on that day the land vested with the government, section 16 of the Act of 1894. The High Court further examined the ambit and scope of section 45 of the Income Tax Act and read along with section 16 of the Act of 1894. So the High Court compared both the section of 45 of the Income Tax Act as well as the section 16 of the IT Act, that is, of the Land Acquisition Act. On such examination, the High Court came to a conclusion that the transfer of the land and its vesting in the government took place on 29/9/1970. So having read through or having analyzed the section 16 of the Land Acquisition Act 1894 and the section 45 of the Income Tax Act, the High Court came to a conclusion that the rights of the land are vested with the government only on the date of award, that is on 29/9/1970. The HC stated that the income tax is not levied on a mere right to receive compensation. There must be something tangible, something in the nature of an obligation to pay an ascertained amount. So it's the High Court made a differentiation saying that there is a difference between one right to receive compensation and a clear obligation to make or to pay the compensation. We differentiated between these two facts and said that from the date of notification there may be a right to receive, but the obligation to pay arises only on the date of award. And hence the CG is chargeable only in the year of award, since only at that time the amount was ascertainable. Therefore, CG shall be chargeable to tax in the year assessment year 1971-72. And at the High Court having ruled in favor of the revenue, the assessee moved to the Supreme Court. So the assessee's contention before the Supreme Court, Honorable Supreme Court, was that the land was already in the possession of the government when notification section 4 of the Act of 1894 was issued, and as per the award dated 29/9/1970, the interest was also allowed from the date of notification, and hence transaction said to have been taken place on the date of notification itself. According to this, the transfer was complete at the date of notification, and capital gains, if any, could have only been charged on the date of notification and not with the reference to the date of award. The assessee continued to make the same claim that here they claim that the acquisition under section 17 has been dropped because the High Court very clearly mentioned that this is not a case of acquisition under section 17 of the Land Acquisition Act. It is a case of acquisition under section 16. So hence the assessee contested on two grounds. One, that the possession of the land is already there with the college on the date of issue of notification itself, and then interest has been paid on the compensation from the date of notification itself. So these two facts substantiate ASCI's claim. Further, the ASCI referred to the Kerala High Court case in the case of Peter John, where the Kerala High Court held that the owner of the property is entitled to compensation on the day on which he is dispossessed, and then such right does not await quantification of compensation by the authority. And that means here the Kerala High Court held that the ASCI has the right to receive compensation on the date on which he has parted with the possession of the land, and it does not wait till the time the quantification of the compensation is made. On application of these principles to the case at hand, the date of award 29/1970 for quantification of the compensation has no relevance, and the only relevant date is 15/5/1968. This is what the ASCI has claimed. And further, the ASCI also referred to one more case of the Supreme Court, Ramabai versus CITIA. The interest income in cases of land acquisition accrues from the year to year and is taxable in the respective year of its accrual. The present case in the portion of land was taken on 15/5/1968. Capital gains and interest accrued were taxable only in the year assessment year 69/70 and not in the assessment year 71/72 as constructed by the revenue. So ASCI further contested that by relying on the case of Berger Paints, wherein it was held that the order passed in favor of the very same assessee and against the revenue in a similar matter has attained finality, the revenue cannot seek reopening of the issue in relation to the other case without a just cause. So as we said earlier, the ASCI had one more case of almost similar facts for the assessment year 1975-76, which was ruled in favor of the ASCI, saying that the transfer said to have been taken place on the date of notification. So ASCI has referred to the Berger Paints case, stating that wherein it was held that where there are two cases of the same assessee and one has having been concluded, the revenue cannot put forth or argue for the second case without any just reason. So ASCI said that since the 75, the case related to assessment year 75/76 has been ruled in his favor, the revenue should not be allowed to take up this case against him. Now the revenue's contention before the Supreme Court was that the revenue referred to the definition of capital asset and transfer as per the Income Tax Act, and further it contended that though possession of the land was with the college, gain on account of transfer of land accrued only on the date of award. The revenue further stated that the acquisition had not been under the urgency provisions contained in Section 17 of the Act 1884, and the government did not issue directions to take possession after the expiry of 15 days from the date of publication of the notice under Section 9(1). So there are a couple of important points here. One, the acquisition is not an acquisition under Section 17 of relating to urgency matters. Okay, so only in case of, we will see the difference between Section 16 and Section 17 of the Land Acquisition Act just in the next couple of slides. So before that, I'll just highlight that the Section 17, under the acquisition of Section 17 of the Land Acquisition Act relating to urgency matters, in such cases, the possession shall or the rights of the land shall vest with the government immediately upon the expiry of 15 days from the date of notification. But such regulations is not applicable to acquisition of Section 16. Okay, so that is what revenue is contested. Since High Court has very clearly ruled that this is not a Section 17 acquisition, the revenue argued that since it's not a Section 17 acquisition, the transfer shall not be construed to have happened on the date of notification. So just in this slide, we'll analyze the land acquisition provisions of the Land Acquisition Act. So first, the Section 4, that is where the publication of the preliminary notifications and powers of officers thereupon. So here, under first, when the government intends to acquire land under compulsory acquisition, it notifies under Section 4. Later, under Section 5A, it allows for any person interested in the land to be acquired to object within 30 days for that such notification. After that, it makes a declaration, the government makes a declaration that that land is required for public purpose under section 6. Next, further issues notice to the interested persons under section 9. Next, it makes inquiry and makes award under section 11. And here comes the important point, section 16, power to take possession. So when the collector has made an award under section 11, he may take possession of the land which shall thereupon vest absolute in the government. So here it is important to note that under section 16, the collector has the right to take possession only after making award under section 11. This is very, very critical for this case. Okay, so under section 16 of the Land Acquisition Act of 1894, the collector has the right to take possession only after making award under section 11. However, a different process under section 17 has been prescribed, wherein in the case of urgency matters, the collector shall take the possession of the land on the expiration of 15 days from the date of publication of the notice under section 9(1). As I said, there are section 16. For the acquisition of section 16, the collector has the rights to acquire or take the possession of the land only after determining the award. Whereas under section acquisition under section 17, the collector has the right to take the possession of the land immediately after the expiration of 15 days from the date of notification under section 9. So just a comparison, okay, between section 16 versus section 17. Okay, as I said, the power to take possession in section 16 arises only after the award is determined under section 11, whereas in case of section 17, which is for urgency matter for public purpose, the right to take possession vests with the collector immediately after the expiration of 15 days from the date of notification. These are the two important distinctions between section 16 and section 17. So further, further the Supreme Court analyzed the Transfer Properties Act 1882. Because section 5 of the Transfer Property Act defined in the following sections, transfer property means an act by which a living person conveys property in the present or in the future to one more other living person. So what happens? The Supreme Court analyzed the definition of transfer under section 5 of the Transfer Property Act, and further under the rights and liabilities of the lessor and the lessee under section 108, and further section 116, effect of the holding over. So under these sections, the Supreme Court analyzed the what are the rights and liabilities of the lessor and lessee, and when is the transfer said to have happened, and further the effect of holding over. So what happens is under section 108, the lessee, upon expiry of the lease period, is supposed to hand over the possession of the land immediately to the lessor, and if the lessor allows the continuous possession of the land with the lessee, or if he accepts any compensation for the excess period, the lease is said to have been automatically renewed. So in this case, the assessee allowed the college to continuously enjoy the possession. So in other words, the lease, though though the lease is said to have been expired as per the agreement, but since the assessee has allowed the college to enjoy the continuous possession of the land, the lease is said to have been automatically renewed. So further, the Supreme Court, so the cases whichever has been referred by the assessee in his argument, the rebuttal for that has been issued by the Supreme Court, saying that the right to receive the compensation shall not be deemed to be the date of transfer. That is what the assessee has mentioned. So that is what the Supreme Court had ruled. Further, the Supreme Court referred to various cases in while pronouncing the judgment on this matter. One is the governor of Himachal Pradesh versus Avinash Sharma. In the present case, the notification under section 17(1) and 4 was issued by the government, and possession which had previously been taken from the date of expiry of 15 days from the publication of the notice, be it deemed to be the possession of the government. In this case, so in the case of this Himachal, Avinash Sharma was the governor of Himachal Pradesh. It was an acquisition under section 17. Hence, the Supreme Court ruled that the possession is said to have been vested with the government from the expiry of 15 days from the date of notification. Whereas in the case of Pandari Lakshman, the Supreme Court held that the possession of the land was taken on 3/8/1977, whereas the notice under section 9(1) was issued on 25/1980, and award was passed on 25/3/1981. This is more or less similar to the facts are similar to the present case. The High Court held that the relevant date for vesting of the land in government would be the date of making the award. So in this case, the facts are very similar to the present case here. If you see, the date of possession is 3/8/1977. That is even before the date of notification on 25/1980, and the award was passed on 25/1981. Even in this case, the possession is there with the college even before the date of notification. The date of notification has been the notification issued at a later point, and the award was decided on September 1970. So in a similar case, the High Court held that since this is a case of acquisition under section 16, the rights of the land is supposed to be vested with the government only upon the fixation of the award, or only on the when the award is fixed. So in this case as well, the Supreme Court goes on to say the same thing. And there is one more case. I'm not going into the details because the content or the rulings are been similar in the other case as well. I'm not going into detail because the more or less all the cases are reiterates the same fact. So now, having gone to analyze the facts of the case as well as the other relevant case laws, the Supreme Court stated that as per section 247 of the IT Act, that is which deals with the transfer in relation to capital asset, includes the compulsory acquisition thereof under any law. So that means, and this is very clear, it's straightforward point. And as per the Land Acquisition Act 1894, there are only two ways to acquire the land. That is under section 16, normal route, which is an ordinary acquisition, and section 17 in case of urgency. The Supreme Court referred the decision of Andhra Pradesh High Court in the case of Appala Narasamma. Okay. And in the case, the possession of the land was voluntarily transferred to the government before the date of the award, but the SC held that the date of transfer shall only be the date when the award was ordered. As similar to the current case on hand, in this case as well, the SC transferred voluntarily the possession to the government. However, the High Court held that even though the SC has voluntarily transferred the possession to the government, the date of transfer shall be regarded only with reference to the date of award and not the date of possession of the land. So in the decision of the case of Avinash Sharma, however, supports the view that in the case of urgency acquisition, even if possession of the land under acquisition is taken earlier, it should be related to the process contemplated under section 17 of the Act, and the possession is deemed to be effective from the date on which the period of 15 days gets expired from the date of publication of notice. So even so, in all these cases, it is evident that even though the possession has been transferred earlier, the date mentioned or the date mentioned in the Land Acquisition Act shall take precedence over the date of possession. That is, in the case of section 17 acquisition, it is 15 days from the date of notification, and whereas in the case of 16 acquisition, it is from the date of award. So irrespective of the date of possession, the date of transfer shall be based on these two dates. So now, having gone through analyzed all this, the the completion of transfer with the vesting of land in the government essentially correlates with the taking over of the possession of the land and under acquisition by the government. However, where possession is taken over before arriving of the relevant stage for such taking over, capital gain shall be deemed to have accrued upon arrival of the relevant stage and not before. The same point, the point which has been explained earlier, has been read by the Supreme Court here. So irrespective of irrespective of the fact the question has been taken over earlier, unless the respective stage as mentioned in the Land Acquisition Act arises, the transfer shall not have been taken place. So only whatever only on the date on which the possession or the rights is said to be vested with the government as per the Land Acquisition Act, transfer is said to have taken place. So I'm not, so since having explained the important facts, I'm not going into detail of these points of other facts. And now we will most importantly analyze or compare the compulsory, because now the Land Acquisition Act of 1894 has been replaced by Land Acquisition Act 2013. Okay, so under this, let's compare the provisions of Land Acquisition Act 1894 with that of the Land Acquisition Act 2013. So as we have seen the provisions of Land Acquisition Act 1894 in the previous slides, so I'm not going in that part. I'll focus on the Land Acquisition Act 2013. So similar to 2000, section 16 of the Land Acquisition Act 1894, we have section 38, which relates to normal acquisition under Land Acquisition Act 2013. So in this case, section 38 states that the collector shall take the possession of land after ensuring that full payment of compensation as well as rehabilitation resettlement entitlements are paid or tendered to the entitled person within a period of 3 months from the compensation, 3 months for the compensation, and period of 6 months for the monetary part of the rehabilitation and resettlement entitlements listed in the second schedule, commencing from the date of award made under section 30. So here, the previous, that is the Land Acquisition Act 1894, the possession is said to have been vested with that is right to possession is said to have vested with the collector upon fixation of award, whereas in the new act, the act which is under relevance now, the collector has the right to take possession only after ensuring that the compensation is paid to the landowner within 30 days from the date of award, and for other rehabilitation, so within 3 months from the date of award, and ensuring that within 6 months all the other rehabilitation which has been promised has been fulfilled. So in other case, in the case of the Land Acquisition Act 2013, section 38 acquisition of normal land compulsory acquisition, in such cases the possession will said to have been with the or the transfer is said to have been taken place only after completion of 3 months for the payment of compensation, and the cases where additional rehabilitation entitlements has been promised. In such cases, it is only after 6 months. So, in the under the Land Acquisition Act 2013, the transfer shall be said to have taken place only after the completion of 3 months or 6 months, as the case may be. In cases where the additional rehabilitation measures have been promised, only if all those measures which have been promised has been paid to the landowner, only then the transfer is said to have taken place. Otherwise, it shall still the transfers, though the possession has been taken over, transfers will not be said to have happened. And whereas section 40 of the Land Acquisition Act 2013, which is similar to section 17 of the 1894 Act, in case of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, may, on the expiration of 30 days from the publication of the notice mentioned in section 21, take possession of any land needed for a public purpose, and such land shall thereupon vest absolutely with the government, free from all income. So in this case, just only the number of, there is a only difference between number of days. In the earlier act, it was 15 days from the date of notification for urgency matters. Now it is 30 days. Whereas in the case of the normal acquisition, two dates has been mentioned, that is 3 months from the date of award and 6 months from the date of award. And in addition to the number of days, within that time limit, the compensation should have also been paid to the landowner. Only then the collector has the right to take over the possession. So now what? And one other important point is, we have already there in the past seen cases where the Honorable Supreme Court has ruled that transfer is said to have taken place on the date on which the possession has been transferred. Okay, so there is an important distinction between the two scenarios. Okay, though the Supreme Court has held differently in the other cases, the distinction is the cases in which the Supreme Court has held that the transfer of possession itself is amounts to transfer of property under the Income Tax Act is relating to the, it is not relating to compulsory acquisition. It is the regular acquisition, and which exclusively falls under the domain of the Transfer of Properties Act, and the SC has referred in such cases to section 53A of the Transfer of Properties Act, wherein even under section 53A of the Transfer Property Act, where there is a contract between the buyer and the seller, and the buyer has partly fulfilled the terms of the contract, and he has shown the willingness to fulfill the balance remaining part of the contract, and has taken possession. In such cases, even before the registration, where part of the contract has been fulfilled and possession has been taken over, in such cases, possession shall be deemed to be the date of transfer. But in the case of compulsory acquisition, the date of possession does not have any relevance. We have to strictly go as per the provisions of the Land Acquisition Act. So that's why in this case, even under the new act, this case has a relevance. Even under the Land Acquisition Act 2013, whether it is section 38 acquisition or section 40 acquisition, we have to go purely as per the Land Acquisition Act to determine the date of transfer, and should not rely on the date of possession. Date of possession is important only in the cases in which, in a normal case of transfer, and that too in cases where section 53A is relevant. That is where there is a contract and part of the contract has been fulfilled, and the buyer is willing to shown interest or shown indication that he is willing to fulfill the balance part of the contract as well, and has taken possession of the property. In such case, a possession shall be deemed to be date of transfer. But in case of compulsory acquisition, the Land Acquisition Act 2013 or 1894, as the case may be, will take precedence over the Transfer of Property Act. Section 53A shall not be applicable there. So as I stated earlier, in this case, in the relevant case, since it's a case of land compulsory acquisition, the Land Acquisition Act 1894 takes precedence over the Transfer of Property Act, and hence the date of possession is irrelevant. And then in the case of compulsory acquisition, we need to check whether it is the acquisition under normal procedure or under urgency matter. In case of urgency matters, it is from the 15 days or 30 days, as the case may be, based on the relevant act, that is 1894 2013, the transfer is said to have taken place. Whereas in the case of normal acquisition, in the case of 1894 act, it is the date of award, whereas in the case of 2013 act, it will be 3 months or 6 months from the date of award, and subject to condition that all the commitments which the government has given to the landowner is fulfilled. In other words, 30 days or the 3 months or 6 months from the date of award, or the date on which the commitments are fulfilled, whichever is later, shall be treated as the date of transfer under Land Acquisition Act 2013. So hence, though this case as per se relates to assessment year 70, 71 and 72, okay, and Land Acquisition Act 1894, the judgment is still relevant even considering the provisions of Land Acquisition Act 2013. So if you have any doubts, feel free to write to us or comment on our YouTube page. Okay, thank you.